Silicon Flatirons is a research center at Colorado Law School. We work with students to give them the tools they need to pursue careers in tech, law, policy, and entrepreneurship.
When I started, Silicon Flatirons was an experiment. It was me and some students putting on a few conferences without really a plan where it was going to go. My initial motivation was because I didn't believe you could have impactful policy discussions unless you brought people together across different disciplines. Silicon Flatirons Center has given me an image of what a team can look like.
And it really made Boulder into a location that was seen as on par with DC or Silicon Valley and other places around the country that are leading thought centers in the field of law and tech.
What's excited me the most is to see it grow, but not only just grow in terms of the number of people attending our different events, but growing in terms of the different areas that we have been involved in.
When a law student says, I've got a passion for understanding the intersection of technology and law, but where do I get started with that? What Flatirons provides is a position to actually go angle for a job during their second summer, where they're actually going to get to be involved directly in setting tech policy or in advocating around tech policy.
The Silicon Flatirons community is incredibly unique in how close it is and how people are willing to band together to move conversations forward.
It's one thing to be sitting in a room by yourself reading articles, and it's very much another thing to actually be sitting at a table talking to somebody about their daily experiences of trying to navigate compliance with a complex new law.
We're all a community of friends who enjoy spending time with one another.
The people we engage with through here are very much thinkers and thought leaders, so they're contributing to whether it's our strategy or our resources in really meaningful ways.
Silicon Flatirons has changed the dynamic between Colorado law and the surrounding community as well as the national community.
One of the great joys of my profession is talking to people who are really early in their careers and helping them get excited about what you're excited about.
We get the types of people in the room that everyone thinks should be talking to one another, but often are not.
I get to work with students, I get to work with attorneys, I get to work with policymakers at the intersection of all these issues.
Students are first and foremost, so everything is generally student-driven.
And it is centered around people who are wanting to engage with students.
I've seen students come into Silicon Flatirons just having a little interest in it, in year one, and by year three, they're passionate about it and they found their career.
And I think that really helps the standing of the university more broadly, and it also attracts lots of really interesting and talented speakers.
I think what I'm excited to see happen with Silicon Flatirons in the next 5, 10, even 20 years is for it to blend continuity with change.
It's not enough to have smaller conversations anymore. The world is all connected, and Silicon Flatirons is going to reflect that global nature of the internet as we move forward into 20 years in the future.
I hope it continues to operate with the same spirit of experimentation, of adventure, of seeking out new challenges that we've done over the first 20 years.
Good morning, everyone. Thank you so much for joining us in the virtual format. My name is Vanessa. I am the Senior Events Manager for Silicon Flatirons. Just want to make a quick housekeeping note that today's panels are in the Zoom webinar format. That means if you are not a speaker, just in the audience, we cannot see or hear you, so there's no pressure. You can't even turn it on. We will have Q&As at the end of each panel, and we encourage your questions. Also note that at the end of today's program, we will be trying out a virtual networking reception. If anyone's feeling brave and social and wants to talk about our event. So without further ado, I will turn things over to Associate Professor of Law, Scott Skinner-Thompson.
Thanks so much, Vanessa, and welcome to all of you, and thank you for attending today's discussion regarding cross-border data regulation in a post-privacy shield world. As Vanessa indicated, my name is Scott Skinner-Thompson. I'm a professor here at CU Law, focused in part on privacy rights for marginalized communities. And I'm thrilled to be moderating our first panel looking at the implications of the decision of the Court of Justice of the European Union in the Schrems II case. Put more bluntly, what went wrong and what comes next. Before I go any further, I want to acknowledge that many of us in the United States are on the lands of First Nations peoples. In Boulder, we are on the traditional lands of the Cheyenne, Arapaho, and Ute nations, and I'd like to pay particular respects to the elders past, present, and emerging who lead these communities. We have a really tremendous group of panelists here with us today, and I'm going to let them introduce themselves before we get rolling. Ted, would you mind doing the honors of introducing yourself first, and then Alex, Estelle, and Edith?
Sure. Ted Dean. I'm the head of public policy at Dropbox, based in DC. From 2013 until the end of the Obama administration, I was a Deputy Assistant Secretary in the U.S. Department of Commerce, where my office administered the Safe Harbor program and then the Privacy Shield program. And I led our negotiations for creation of the Privacy Shield. So I'll pause there. Thank you.
Hi, yes, thank you for having me here. I'm delighted to be here. My name is Alex Joel. I am a scholar in residence and adjunct professor at the Washington College of Law in American University, and I love that title, scholar in residence. Before coming here, I was for 14 years the Civil Liberties Protection Officer for the Director of National Intelligence, which is the organization that leads and coordinates the intelligence agencies, and I was there since stand-up of that office. And before that, I had other things going on in my career. But as part of the ODNI, I worked with Ted and Edith and others, mostly behind the scenes on the intelligence response to the European Union's concerns about our programs, which are reflected in everything that's happened regarding Privacy Shield.
Hi, my name is Estelle Masse. I'm a senior policy analyst at Access Now, which is an international NGO that works to defend and extend the rights of users at risk around the world. I'm based out of our Brussels office, and I've been working here over the past 6 years or so on data protection and privacy globally. I was there when the Safe Harbor fell and worked through the negotiation of the Shield, and had the pleasure to be seeing on both sides how it went. We represent users globally, so our focus is very much to ensure that their rights are respected in whichever deals are being negotiated between the government on both sides of the Atlantics.
And hello, everybody. Delighted to be here with all of you. My name is Edith Ramirez. I'm a partner at Hogan Lovells, where I focus on privacy and antitrust. And from 2010 through the end of the Obama administration, I was a chairwoman and commissioner at the Federal Trade Commission, where I had the opportunity to, has already been noted, to work with Ted, Alex, and others in connection with negotiations leading to the Privacy Shield.
Wonderful. Thank you so much to all of you for being with us here today. Before we get started in earnest, just a reminder, we will be having Q&A at the end. So if you have questions, feel free to type them into the Zoom Q&A function, or you can use Twitter, hashtag Silicon Flatirons and at Silicon Flatirons. And we'll try to integrate those into the Q&A as well. We'll do the question and answer period at the end, but feel free to start populating at any point. With that, Alex is going to get us started with a bit of an overview, background on the Schrems II case, the GDPR, and the Safe Harbor, the predecessor to the Shield.
Yes, we'll see if I can do this in a lightning round to try to get us all on the same page. We have a lot of people participating, which is great, and I assume you all have varying degrees of familiarity with what we're talking about here. So I'll try to lay the groundwork, and my fellow panelists can correct anything I get wrong or anything important that I skipped, but I will not make this the full course it could be. Okay, First thing to understand is that we have different approaches to privacy in the United States and in Europe that are essentially different approaches to how we regulate it as a legal matter. So the US is often characterized as having a sectoral approach. What does that mean? It means that we have laws that govern, for example, financial privacy, healthcare privacy. We even have a law on video rental privacy, video rental records, one of my favorite statutes. And so that's considered a sectoral approach. We do have what is sometimes referred to as this catch-all statute, the FTC Act, which Edith is of course intimately familiar with, which helps fill in the gaps of privacy that might be left by some of these sectoral laws that I just described. By contrast, the European Union has something right now that's called the General Data Protection Regulation, or GDPR. It is a comprehensive, seemingly across the board approach to privacy protection that applies to any entity that is processing or making decisions about personal data of people in Europe. So that's at a very high level, different ways of thinking about the two different approaches. So going back to 1990, in the 1990s, 1995, the European Union issued something called the Data Protection Directive. Now, what that directive said was, hey, let's take a common approach to protecting privacy in the European Union. And it directed member states to issue laws or harmonize their laws with a list of key privacy principles, very detailed list of privacy principles. One of those principles governs how personal data can be taken out of the European Union and be processed or acted upon in another country. So, you can think of it as an export. How do you export data from the European Union, where it's subject to these privacy protections, to other countries where they may not be subject, or they're not subject to exactly the same kinds of protections. So there are different complicated mechanisms for doing that. I'm not going to get into that. But by and large, one of the things that the European Union asks of its sort of government institutions, and it has different institutions, in this case it's the European Commission, is to look at these other countries and determine, hey, are they protecting privacy adequately in that country? Are the laws adequate? Are they essentially equivalent to our protections? And if they're not, then we have to work on ways to raise it to that equivalency level. And so in 2000, the European Union and the United States entered into an arrangement called the Safe Harbor Arrangement. So under Safe Harbor, companies would certify that they're complying with certain kinds of protections which were deemed to be sufficient or adequate for EU purposes. And therefore, those companies that had signed up to Safe Harbor, and there were other mechanisms, but this was one of them, they could get data from their operations in Europe and process it and act upon it in the United States. So that was the Safe Harbor. And notice the terminology, Safe Harbor, so American companies sailing their ships into a safe harbor where they can be safe from the consequences of privacy, what might otherwise be considered privacy missteps if they were in the European Union. So now we fast forward to 2013. We have Edward Snowden, a contractor working at NSA, releases a huge amount of information, creates a lot of consternation. So this is the Snowden leaks, and one of the impacts is that people in Europe get very concerned about what the intelligence practices are of the agencies inside the United States. So I was very involved in that, as were others here on the panel, trying to respond to all of the concerns that came out of those disclosures. And one of the things that happened was a law student named Max Schrems filed a case in Ireland, and this is called the Schrems 1 litigation, trying to challenging the validity of the safe harbor in light of the information that had come to light in the Snowden disclosures. And ultimately that went up through the legal process, resulted in a ruling that invalidated safe harbor. So safe harbor is no longer valid. Basically, the court found that the European Commission had not done its job back in 2000 and had not really looked into how the government might access data in ways that were problematic from the EU's perspective. So that goes out the window. We all then work on something to replace it. And out of that effort, and I won't get into the details because I think Ted will do a little bit more of that. Out of that effort comes Privacy Shield. Privacy Shield is another arrangement where the US agencies make a series of commitments. FTC was a huge part of that Privacy Shield arrangement, but the intelligence community also made some commitments. So we had, before Privacy Shield had been put in place, we had issued a presidential policy directive. The president had issued, President Obama, a directive that extended certain privacy protections to people around the world, regardless of nationality. That was a key element of what the response to the disclosures. Another key element was the transparency. This was an effort that I championed when I was in the intelligence community. I worked very hard to get the intelligence agencies focused on releasing additional information to inform the public about how we exercise our authorities. So there was a huge push on transparency as well. So then we have Privacy Shield. Schrems challenges transfer. It's a different kind of transfer. Again, I'm not going to get into the details of it, but there's another mechanism for transferring data from the EU to the US that companies were relying on after the demise of Safe Harbor. He challenges that. That goes back up to the European Court of Justice, the CJEU, the Court of Justice for the European Union. And the court most recently in Schrems 2 called into question that mode of transfer, but more significantly for our purposes, took the opportunity of having this case before it to strike down Privacy Shield. And it struck it down because, again, it viewed certain intelligence legal aspects of our legal framework in the US to be problematic and not adequate for European purposes. Now, I think I would be remiss if I didn't pause here to point out, I said earlier that we have a sectoral approach to privacy in the United States. That's how it's commonly characterized. And we have in the European Union a comprehensive approach. And I said, I think something like appears to be comprehensive, but the European Union is a creature of treaty. And when the EU member states, now 27 EU member states, because the UK is no longer there, the 27 member states came together to form the European Union and to create the institutions like the European Parliament and the European Commission and their own court, the Court of Justice for the European Union. They reserved for themselves responsibility for protecting their own national security. So in the European Union, GDPR has limited, if any, application. Now I say limited, if any, because there is debate about that. But in essence, there is a clear carve out from the treaty structure that formed the European Union for the national security of EU member states, France, Germany, et cetera. So what the US was trying to argue was you should compare our national security legal framework to the national security legal framework that applies in each of the EU member states, which is different state by state. Every country has their own way of doing that. And that's to be expected. I do not believe that a cookie cutter approach to national security legal frameworks is really feasible, given that every country has very different national security priorities and feels that it's in a very different place in the world and they have very different legal frameworks. But that's getting ahead of the discussion. So the Schrems 2 court didn't compare the US intelligence oversight legal framework with those that are actually operating at the EU member state level. They compared us to what the European Union, to what the court viewed as the appropriate standard for national security access to data. So I'll stop there. I think that's enough of a background. I think I did that quickly enough. I could go on, but I'll stop.
It's perfect, Alex. Thanks so much. Really efficient yet comprehensive stage setting. Thank you. So that's the background, and Ted and Edith are going to take us a little bit deeper into what went wrong and from different perspectives, with Ted leading us off.
Thanks, Scott. And let me just begin by thanking Amy and Silicon Flatirons for convening us. I'm a fan from afar and really happy to get a chance to take part in today's event. Also commend Alex for sort of offering a semester's worth in just a few minutes. I will try to move with similar pace so that we can get into more of a discussion with the panelists and with their guests here today. I wanted to pick up Alex's story by sort of providing a little bit of a sketch of the negotiation we went through when I was in government. Not to recount all of that history or to sort of relive my own PTSD from that experience, but because I think some of that highlights the challenges that are common between that negotiation and the negotiations that are beginning now. but also highlights some of the ways in which the situation we're in today is, in my view, sort of more complex and more challenging. The first thing that I think it's important to note, sometimes this process is sort of keyed off Schrems 1 and that ruling in October of 2015. As Alex mentioned, we began our negotiation with the European Commission soon after the Snowden disclosures. In November of 2013, the European Commission issued a report on the safe harbor framework that Alex mentioned, and made recommendations for improvements that we could make in that program. Because the program was still valid, it had not been invalidated by the court, we began on sort of a process that candidly had somewhat less urgency. We could pursue a sort of gradual process to get to a good resolution. While we were negotiating first on the sort of commercial uses of data and commercial privacy, the parallel process that Alex talked about that led to PPD 28, that led to implementing guidelines at different intelligence agencies for PPD 28 was underway. New transparency that Alex talked about was underway. And as we proceeded with the negotiation and that work that was done in the immediate aftermath of the Snowden disclosures was completed, that then formed the basis for us to go back to the European Commission and talk about those national security and law enforcement access issues. I should say at the onset, because I think it applies to this negotiation that's underway now and the negotiation that we took part in the last administration, that it is in structure sort of an awkward template. The US Department of Commerce administers the Privacy Shield program. We have an interest in data flows by virtue of our interest in supporting international trade, but we are neither a law enforcement nor a national security agency. And so we're a little bit of an odd place to lead this negotiation. Similarly, as Alex noted, and the court noted, though only briefly, the European Commission does not have competence for national security issues. So you begin with a somewhat awkward structure for how the parties will come together and figure out how to work together on these issues. That's a challenge which it's possible to overcome. We did before, and I think there are ways to do it again, but it's, I think, an important aspect of this because it does inform some of the sort of practical roadblocks in getting to a good outcome. We were able to get there in the fall of 2015. We were in fact very close to reaching an agreement with the European Commission. The court then ruled and invalidated Safe Harbor in October of 2015. It sort of provided greater clarity on what they were seeking in terms of essential equivalence in privacy protections. It raised new questions about redress that ultimately led us to the creation of the Ombudsman and led to a very intense period of negotiation because Safe Harbor had been invalidated. There wasn't a valid basis for transfers, and we really had to, with haste, create something new. We were able to reach a political agreement in February of 2016, and ultimately later that year have Privacy Shield approved by the member states. We'll talk, I'm sure, more in the panel, and I'll talk more about some of the limitations in what we did, and certainly the court found limitations in what we did and ultimately ruled it invalid. I think it is important to not lose sight of the progress we made as well, that we were able to reach alignment on these really difficult issues at a political level, that we were able, through Alex's work and others, to sort of drive new transparency in intelligence practices, that we were able to create the Ombudsman, which is the court found fault with, but it's also important to note is not a mechanism that any other countries that I know of provide to foreign nationals, and EU member states do not provide. So with all that said, I just wanted to highlight a couple of things which I think now are different now to sort of pivot to talking about the future. And I'll try to do this as quickly as I can, just focusing on the timing of the negotiations, the scope of the ruling, and the players involved. In terms of the timing, I think it's really important. We benefited from being able to do all of our work in one presidential term, from the Snowden disclosures to reach an agreement on Privacy Shield. I don't want to prejudge the outcome of our upcoming presidential election, but just the prospect of an election complicates the beginning of negotiations today. We also benefited from the fact that those negotiations, as I mentioned, had been going on for almost 2 years when the Schrems I ruling came out. So we had developed a great deal of momentum, trust, I think credibility with our European counterparts. And that was important for the sort of more intense work that we had to do after the Schrems ruling. But it was also very important when we were reaching out to European data protection authorities and seeking enforcement forbearance while we completed our work. We were able to go to the data protection authorities and say, we've been at this for 2 years, we're close, give us time to finish. And they in fact gave us this period of forbearance to complete our work. I don't doubt the work in the Commerce Department or the commission that's been done. I don't doubt the relationships they've built up, but I just think in practical fact, it's a different situation to sort of begin the negotiations from a standing start after the ruling as compared to the work we were able to do before the ruling and then carry it forward. The ruling too is, I think, a tougher ruling to overcome. As Alex, I think, noted, the initial ruling focused on, at its core, the fact that the European Commission had not considered US national security access in their original adequacy determination for safe harbor. They didn't make findings about US intelligence practices or US law. Negotiators now have much more specific obstacles, challenges to overcome that the court has articulated. In the long term, that may provide guideposts that gets us to a more durable solution that can survive a court challenge, but it also makes the work much more difficult, I think, in the short term. We just had more flexibility to work with. A second important point about the ruling is we operated in our negotiation within certain constraints. And one of those constraints is we decided we were not going to seek a change in US law as part of the solution that we developed. In my view, and I don't think everyone agrees with this, but in my view, it's pretty clear that the court is seeking things that would be a change in US law. They may be targeted or narrowly defined, but they are in fact changes in US law. And that obviously is a much more complicated undertaking, both in terms of the negotiation, in terms of the role of Congress, and what will motivate Congress to make some of those changes. And finally, and I'll wrap up because I do want to get on to hear from the other panelists in discussion, I think the constellation of players involved is just a bit more complicated this time. I mentioned we had sort of an awkward structure between the Department of Commerce and the European Commission, but we made it work. We had to deal with stakeholders outside of those two parties, but it was really a kind of bilateral negotiation. If you think laws are going to have to change, the US Congress is going to have to be involved in a different way. Because of the nature of the ruling and what it means for standard contractual clauses, and I'll sort of glaze over some of the detail there, but because of what it means for those, DPAs will play a much larger role this time. In the initial negotiation, they were sort of purely an advisory role, reviewing the final adequacy determination issued by the European Commission. Here, they play a much more active role because of the sort of powers that the court has given them. And finally, I think companies, as I think we'll talk about more in the next panel, are in the really untenable position of having to defend the standard contractual clauses on issues that are really government to government in nature. So I think I've probably opened by painting a somewhat pessimistic picture. I do think this is really challenging, and in some ways more challenging. I remain, as I was in the last negotiation, a sort of optimist by nature. So I do believe these problems are solvable, but I think they're sort of solvable in part by having a very clear-eyed view of what the challenges are. And as I said, in this case, I think they're complicated, and we need to be wary of the sort of full magnitude of the challenges before us. But I probably rambled a little too long, so I'll pause there and pass on to Edith.
Thanks, Ted. So let me jump in to speak a bit about the role that the Federal Trade Commission played during the negotiations with regard to the Privacy Shield. And I will do that because I want to highlight one issue that I feel is an important one, though it is in the backdrop and not quite at the forefront when it comes to the same level of importance as the intelligence practices, but nonetheless that I think is quite crucial, and I'll explain in a moment. So the FTC, as I think most of the audience is likely aware, is the de facto privacy authority in the United States. And the FTC had been involved in the development of the Safe Harbor framework and was responsible for enforcing it. Our role in the negotiations and as part of the team that Ted and others at Commerce led was to effectively act as the experts on the privacy issues, and of course to explain and help develop the enforcement mechanisms for any framework that would emerge from those discussions. And then also importantly, I believe, as a bit of a bridge to the European Commission. As the main privacy authority in the United States, the FTC certainly shares the concerns about privacy, generally speaking. The FTC does focus on protecting commercial privacy, so focusing on commercial information, and so does not have any authority with regard to any of the national security issues at play. But then nonetheless, I think that it was an important conduit to help both explain the landscape in which the Safe Harbor framework operated, and therefore the framework and context in which the Privacy Shield framework that emerged would operate. And that gets to, I think, one of the main points that I want to make here, which is that whenever during my time at the FTC, and whenever there was a discussion with European officials, there was no question that the U.S. was always at a disadvantage simply by virtue of the fact that we lack a comprehensive federal privacy law. As Alex mentioned earlier, the U.S. has this sectoral approach. I think that term, sectoral approach, really obscures the complexity of the privacy framework that we have in the United States. So I think a good part of what we have tried to do during the course of the negotiations was to ensure that European Commission officials understood that the Privacy Shield would be operating within that broader landscape, but in contrast to the approach that's taken in Europe, where the privacy framework rests on this notion of privacy as a fundamental right, the system that we have here in the United States is extraordinarily complex. At the federal level, we've got specific laws that protect information about children, protect financial information, medical data, information that's used to make decisions about consumers, credit, insurance, employment, and housing. And then on top of that, we also have the FTC, which has authority to enforce Section 5 of the FTC Act that prohibits unfair or deceptive acts or practices. And the FTC has really done quite a bit building jurisprudence about privacy, using that broad and general authority that it has. And frankly, I think from the perspective of many, the FTC really did do a robust job of protecting privacy and enforcing the authority that it had, in contrast to what may be perhaps stricter laws in Europe, but where there wasn't, at least certainly at that time, as much by way of enforcement. I think that has changed to some degree, but I think that the challenge is explaining this very complex system to others outside of the United States. And of course, in addition to the protections at the federal level, the states, especially more recently, have really begun to enact a number of privacy laws. Most noteworthy, of course, is the California Consumer Privacy Protection Act. But in my view, it really placed us at a significant disadvantage just from the get-go, by virtue of the fact that we lacked a federal privacy law. Our role really was to, again, help develop a framework that we thought would be robust. But nonetheless, we were absolutely constrained by, again, the fact that there was no federal privacy law, that it was rather challenging to explain the protections that were being afforded to those in Europe. And I will also note that another important, I think, role that the FTC played and has played is to not only be a bridge vis-a-vis the European Commission, but also to engage in significant collaboration with European DPAs. I think that may prove quite helpful given the more enhanced role that they will have, as Ted noted. But that is something that I think is quite vital to enhance the ongoing dialogue across the Atlantic. I'll note that particularly during the Obama administration and under the tenure of my predecessor, John Leibowitz, and in particular the head of the director of the Bureau of Consumer Protection, David Vladek, who did quite a bit of engagement across the Atlantic with European officials. And then and then in addition to that, Julie Brill, who is likely well known to those who focus on privacy in the audience. And then I was also quite heavily involved and made a significant effort to travel to Europe and engage and collaborate with European DPAs. I have less insight and of a window into what's happening today, but I think that has continued. But to me, to my mind, that's also a very significant and important step that has to continue in order for there to be a solution that's both robust and durable. So I think I'll leave my initial comments there, but again, I want to highlight that from my vantage point, it is absolutely critical that our Congress enact a robust federal law. That is something that the Federal Trade Commission, a majority of commissioners, have been calling on for and supporting for years, and I know that the current commission unanimously supports enactment of a federal privacy law. So I'll leave my initial comments there.
Great, thank you so much, Edith. And now we're gonna jump across the pond to Estelle. Thank you for joining us. What is, I think, getting late in the day over there, and to provide a little bit of insight into the European perspective about what went south and what we can do going forward.
Thank you, and thank you very much again for the invitation to the discussion today. I will be obviously speaking from an EU perspective, but you will understand from my comments that I'm obviously not from the European Commission, so this view might be a little bit more critical than what you would hear from an official sitting in this position. Because from our perspective, if we start thinking of what went wrong with the Privacy Shield, is that the Privacy Shield was never fit for purpose. It failed to protect people's rights, it failed to provide certainty for businesses, and it got us 4 years later nearly in the same situation we were when Safe Harbor was invalidated. The changes that happened at the time of the invalidation of Safe Harbor were steps in the right direction, but they were nowhere enough to guarantee an effective right to remedy, a right to privacy, and a right to data protection as requested by the court and by our EU standards. So both 4 years ago and today, we continue to say that surveillance not only hurts people's rights, but it's also hurting businesses. And if we don't address this main issue in the new upcoming negotiation, then it will also hurt data flows. I will address in the second part of our discussion a little bit more specifically what specific reform we would see as necessary in terms of surveillance, but let me just get a little bit more into detail of where specifically we felt that the Privacy Shield was not going far enough and what has led us to this situation. There are main issue that we saw concretely in the text and in the core of the agreement. But it was mentioned a little bit before that both then and now, the issue we're facing are both political and legal. And back then, the European Commission, which is the lead negotiator, really rushed to get into a political deal with the US in order to make sure that the two sides were getting along, and probably did not pay enough attention to the legal side of things. Because already back then, what the court was mentioning was would have needed some legal reform in the US that did not happen at the time. And so we had a shield agreed on the basis of recommendation made to the EU, but they were more a political deal than a legal one. And those legal issues that we still see a need to be addressed now, and were problematic within Privacy Shield, are focusing on three main points: on surveillance, on data protection, which was mentioned by the previous speaker, and on the right to redress. If we go first on surveillance, the main issue is that there were little to no change to the way surveillance program and surveillance practices work in the US as a result of the Privacy Shield negotiation. Part of the complexity was mentioned by Ted already, is that the group of people negotiating this deal actually have very little oversight over surveillance, but it's still the core of the issue on the case on data transfer. And so at the time, instead of having the EU trying to push for some reform of some of the Section 702 or Executive Order 12333, which is under which major surveillance program focused on non-US citizens are being authorized, which were the core of the problem for the EU to look at, were not being discussed or open for renegotiation. And instead, what the European Union did is rely on a set of written reassurances from the US that there would be no indiscriminate surveillance to be conducted under data sent under Privacy Shield. So this was an effort from the US to reassure the EU side, but in practice, this did not change the status or the way surveillance worked, which meant that it would not be enough for the court. If we go to the issue of data protection, I think it's just explained it very well, in the sense that it's not that the US does not have protection on privacy or does not have laws on data protection. It's just that we in Europe do it as a comprehensive law, and the US still lacks a comprehensive data protection framework at federal level. So what the Privacy Shield is, in a way, was an exception granted to the US because of the importance the EU you get in regards to the US as a major partner, that all right, we're going to grant you that exception and do those privacy list and privacy shield principle with you. But by doing this, the EU was being more generous than it is with any other nation, with which it's negotiating adequacy decision. And it was not only lowering its own standard of data protection, but also setting a precedent that if other country wants to negotiate adequacy decision, they probably would not get into that position. Back 4 years ago, having a discussion at Washington on federal data protection law was a sort of a non-starter. I think things have changed quite a lot now, as it was mentioned. So that's maybe also one area to look forward in getting forward in future negotiation. And then on the third point, on access to remedy, and that's perhaps the place where the US actually made the most move towards the EU in the previous negotiation. So there was the adoption of the Judicial Redress Act at the time, which we still consider was probably not enough, but was a step in the right direction, and there could be a discussion on how to improve it even more. And there was also the creation of the ombudsperson, which was already mentioned. So we had a lot of doubts on how this new figure, the ombudsperson, would in practice help get redress, but we acknowledged that it was something new and something that the US was granted to European citizens, not to anyone else. So still was a step in the right direction. But I do want to say here that one of the issues we had with the system is that beyond the procedural question we had on how to reach it, for many years, actually, after the Shield was adopted, for almost 3 years, the position of the ombudsperson remained vacant. So for about 3 years, and the Shield lasted for 4, so it's quite problematic. But particularly because even though they were always an interim appointee, and specifically if it was used, there would be someone responding to it. But if you think about it from an EU perspective, is that there is a lot of effort being put into some sort of negotiation. There are systems being put in place. And as soon as the deal is signed, the US does not meet one of its main commitments, which is to appoint an ombudsperson for 3 years. So when you start questioning whether the other side is fulfilling this part of the contract, that puts also in question how the whole system works. I'll leave it here for now on what went wrong, and I'm sure there will be, we can continue discussion on that. But those 3 points for us, surveillance, redress, and data protection remain still the 3 core issues that will need to be discussed for the long-term and short-term solution we all now need to work on in order to find sustainable ways to do data flow between the two parties. Thank you.
Thank you so much, Estelle, and thanks to all of you. You know, listening to you all, which was super informative and helpful. If I were to summarize or categorize, I feel like you identified a few different groups of problems, and they, you know, some of them are institutional. A couple of you mentioned, you know, Congress's role to have a durable solution. Do we need Congress to pass legislation? Other institutional problems include, you know, that this is being negotiated primarily through the Department of Commerce and excluding, or not primarily including intelligence agencies. But then substantively too, and I think, you know, this was gestured to, but you know, definitely resonates with me. There's a linguistic and a substantive disconnect in how people think about privacy, and the whole framework is set up to think about it in terms of commodification, data protection, think about data as a commodity as opposed to something more fulsome in the way of rights. So I think that those, you know, both institutional and substantive differences are not going away, right? And so how going forward, how do we overcome those obstacles? Any sort of solutions that you might have?
I'm happy to jump. Or Alex, were you unmuting? Do you want to start? Or?
Yeah, I was going to jump in, but you can, Ted, if you want.
Go ahead. Go ahead. I'll
okay.
follow.
So it's a huge question, right? And there's a lot going on. So I'll just try to just do a couple of things. One is, in my own view, it's helpful to try to divide things up into short-term versus long-term, and to think about the various actors that are involved, right? So anything that requires Congress is a longer-term solution, obviously, because it's just going to take a while for Congress to act. We have an upcoming election. Similarly, because of the upcoming election, anything that requires the president to act could also be something that would, you know, you may feel like it would probably be better to wait until after the election. So right away, you have some boundaries on what is doable in the short term based on those just constraints. But there are things that people can work on in the short term. And I think it's helpful to think for companies and for government representatives to start thinking, well, what are the things we can do now? How will they be durable? How will they be helpful in achieving a longer term solution? So that's just one time dimension issue. I did want to get to a more specific item. I think Ted might have been misunderstood when he mentioned the institutional issue on the US side regarding Commerce's role. We operated for Privacy Shield as a team. So there was a whole interagency process, a whole team effort underway, and the intelligence community was very much a part of that. So it wasn't as if Commerce was out there on its own doing stuff and then we would read about it in the paper the next day. It was very much, anyone who's been in government at the federal level knows what the interagency process is like. There's a lot of meetings, a lot of communications. They can be endless at times, but there's a lot. It's always better to have more communication than less at the interagency level, I always feel, and I think we did that extremely well thanks to Ted's leadership and others at Commerce who were helping pull everybody together on this, and we were very forward-leaning from the intelligence community perspective. I will say that one of the things that that would help in terms of finding a durable solution is one that is an international one, and one that's not just focused on this particular aspect of the U.S. system versus that particular aspect. The Schrems II decision applies to the world, so any country that is getting data from the EU is now going to be subject to this standard. And the standard was established by the CJEU without focusing on the national security practices within EU member states. So when we're thinking, and this has been a huge problem for the US side, for US lawyers to wrap their heads around as well as policymakers, we're being held to a standard. Okay, that's fine. What is the standard? The standard is equivalency. The data should be handled with an equivalent level of protection to how it would be handled in the EU, except that there's a footnote there. It's a theoretical standard for the EU side. It's not, in fact, factually based on how the data is handled at each of the member states, or even picking a few model member states to focus on. It is a theoretical standard based on the EU Charter. Now, I'm not going to criticize, how the court read the EU Charter, et cetera, but I think from an American perspective, it's hard to compare ourselves to this theoretical standard when we know on the ground that there are different things happening at different EU member state levels. And the EU itself has done studies of how intelligence oversight is very different from member state to member state. So I think any solution is going to have to take that into consideration.
Yeah, it's an interesting point. You made it in your initial remarks as well. And I think, Estelle, did you want to jump in on that point quickly, and then we'll get back to Ted?
Sure. So I think I would half agree with you in the sense that it's not that our standards are not being upheld here. It's obviously the EU and Europe is a very complex system. And so we have, obviously, in Luxembourg, a court that is upholding the EU treaty, the EU Charter, and EU legislation, including the General Data Protection Regulation, and has mandate to look into adequacy decision. And unfortunately, we also agree that they are not looking at the moment into national security. We still lacking actually a definition of that, to be very clear, in Europe, and we're still pushing because this limitation that EU member states are still trying to put on the EU of that you cannot enter into that area is starting to blur a lot, and we're hoping that it will also disappear. But we have a second court and a second convention, and a convention, which is the European Convention for Human Rights, and the Strasbourg Court, where we can, as citizens, send our national security laws there to be reviewed and also issue binding decisions. So it's all a little bit complex, but the EU Charter is based on that convention. And the EU has to also follow what this convention is doing, because all of the member states are party of that convention. So it's not clear cut, and it's also difficult to see how the two are linked. But one of the points actually we are discussing and we were considering for this renewed negotiation is how to involve the Council of Europe, which is overseeing this convention and where discussion on intelligence can happen, together with the EU Commission, in order to have those two conversations to happen, because the state of surveillance is Europe is not good. It needs to be fixed, and we also need to get that in order. But from our perspective, it's also not a point of like, well, you guys are doing it too, therefore we should be able as well. There is a global surveillance problem that needs to be fixed, and totally agree that we need to fix it too. But it's not that we don't have those standards enforced, they're enforced in another court, and that just makes the situation maybe a bit more complex.
Yeah, if I could just jump in, I totally agree with that. So there is something called the European Convention of Human Rights, and that has dealt with the national security issues, but that's not part of what the EU court was basing its decision on. So there's this split in the legal standards, and I personally would welcome discussions along the lines of what the European Convention of Human Rights and the European Court of Human Rights has been doing, because they've been dealing with national security issues. The other thing I'll say is just that it's hard for people who have not been doing oversight over intelligence activities to understand what's doable and what's not doable, and what is the actual standard for something. And my final point on that would be the transparency work we've done in the US has been really transformative, I think, in terms of the public's ability to understand what the US is doing. It took a huge lift, and it was extremely risky for the US to do that, but we did that, and we're still doing it. And that's not something that you're going to see happen on a widespread scale around the world. At least it's not happening now in terms of transparency about national security practices.
Thanks so much to you both. Ted, go ahead.
Yeah, I would just first to agree with Alex's point about the need for sort of short-term thinking and long-term thinking. We're not going to get a big agreement in the short term. So if we believe that data flows are important, if we believe that privacy protections in the interim are important, we need to do things that make the system work in the short term as best we can, or minimize the damage, while looking for a long-term solution. I also want to, of course, second Alex's point about the interagency process. If I had been freelancing on intelligence equities, I'm sure I would have been reined in at some point while I was in government. My point was only that establishing the relationships and process to make that work, given commerce as the home of the negotiation on the US side, takes time and is just one more complication people need to be aware of. I also think on this question, there's sort of a legal question about that Alex was making about essential equivalence and essential equivalence to what, and is it to member states' actual activities or to a theoretical standard? I'd put a finer sort of political point on that, which is if you believe Congress has to act to get to a long-term durable solution, in my view, there will not be a political will to act by Congress in a negotiation that is both one way and theoretical and to a theoretical standard. And so that's in large measure why I think we need to do so much work on the short term to create space, because of what I'm about to describe really takes time. But ultimately, if you want changes in law and you want US elected representatives to believe that it's in the national interest of the people who elected them, they're going to have to see this as leading to something that's a framework that doesn't just constrain the United States, but appropriately balances the equities and leads to privacy and security. This ultimately has to get to some outcome where it's a sort of both and not a either or we're not going to, as a political reality, we won't see changes in US law. And that's sort of, one of the obstacles that ultimately before you get to a longer term solution.
Great. Well, the questions are pouring in, but I want to give Edith an opportunity to chime in further on where can we head next.
Look, I guess I'll just finish by saying that I certainly agree with what Alex and Ted have been saying. I do believe that it's a more challenging environment today than it certainly was when the three of us were involved in negotiating a replacement for the safe harbor framework. At the same time, I'll say that I'm cautiously optimistic because I do believe that the stakes are quite high. And I believe that this understanding of what is at stake really motivated the discussions the last time around. And frankly, the Schrems 1 decision was issued in the fall, and by by July of the next year, we had a new framework in place. And here, no question, there's much more challenging. Not only do we have an upcoming election, there are other circumstances that have made the U.S. unfortunately more isolated from the rest of the world in Europe. But I hope that those can be overcome given what's at stake, because there's no question that the free flow of commerce and information serves the interests of millions of consumers across our two continents. So we absolutely do need a durable and, of course, sufficiently protective mechanism to ensure information flow between the United States and Europe. I'll just end by saying that I feel that it is in everyone's interest here in the US to really push our Congress for federal privacy legislation. And I would urge, as I did during my tenure at the Federal Trade Commission, not only policymakers to head in this direction, but I think it's extremely important for the business community as well to realize that it's in their interest, as I think they have now that California enacted its law, to push for federal legislation as well.
Thanks so much, Edith. So now we're going to turn to audience questions, and consistent with Silicon Flatiron's practice and the so-called Weiser rule from our former dean, Phil Weiser, we'll start with the student questions. So Matt Fetter, let's have it.
Thank you, everyone. It's been a really fun talk, and good to see you again, Professor Skinner-Thompson. So Ted, you did answer my initial question in your last remark, but I wanted to get an idea of what type of short-term durable solutions there may be, given that to me it appears from my lack of understanding, but kind of newness in this space, that the Privacy Shield and the Safe Harbor generally were Band-Aids. But without a change in US law, now that those have been struck down, what other types of durable short-term solutions do you think are achievable?
So if you know you need a long-term solution, almost by definition, the short-term solutions are not going to be durable. So I'll concede that at the onset. I think the things that I would be thinking about are what are ways that you, that governments, and I'm speaking to someone outside of government now, but I was in government, what are trust building and signals you can send that create time and space for good faith negotiations? What are things that you could do that would lead data protection authorities to provide some period of forbearance? And what are ultimately, again, if you know you need a long-term solution, we know that whatever is done in the short term is going to end back up in court somehow. And so what are those things that you can do? And I think a lot of the work and thinking that's being done now is focused on standard contractual clauses to get a little wonkier for a moment. But what you can do to buttress standard contractual clauses so that as companies review them, as data protection authorities review them, and as ultimately the courts may review them again someday, you're in as strong a position as possible, knowing that in the end, you still want to get to a government-to-government solution.
Good, and there's several questions actually about people are very interested in the comparing the U.S. and EU standards and the discussion about whether or not, in effect, the CJEU was holding the U.S. to a higher standard than it was European nations. And the questions come from both sides. Some people accuse the CJEU in their questions of quote-unquote hypocrisy, and others believe that the U.S. surveillance is much more unfettered and lawless in terms of its access to U.S. citizen data and foreign citizen data. And so I guess, I'll just briefly have us revisit that topic. Is it, do you have the sense that it's true that the U.S. has more access to citizen data than Europe? And if that is true, then why is the CJEU, why is it hypocrisy for them to call us out?
So let me try to answer the question this way. So intelligence agencies all are going to seek access to data. That's if you're not seeking access to data, then you're not operating as an intelligence agency. Every nation around the world has intelligence agencies. Every nation's intelligence agency is doing things that it feels under its legal framework is appropriate to do to protect the nation from whatever threats that nation's government and system of government generates as priorities for the intelligence agencies to do. So yes, the US has intelligence agencies. We're proactively seeking data in the US intelligence community, as are the EU member states' intelligence agencies. We're all pursuing goals that we think are laudable. Our legal system is been formed over a series of responses to crises, I would say, to focus a lot of the legal framework over many decades and even centuries, going back to the formation of the country. You want to protect, the US system is designed so that we are worried about foreign threats. And so we have created an intelligence framework to guard against foreign threats. If that intelligence framework is turned inside on our citizenry, that is a huge red line that we should never cross, right? And of course, there are all kinds of incidents where that does get crossed, where people worry about it getting crossed. I'm not saying it's perfect, but the focus of the intelligence framework has been, you have these authorities, you have the ability to keep things secret, use those authorities to protect the nation from foreign threats. So when other countries look at our framework and they say, well, wait a minute, your framework is all about protecting Americans. And I say, yes, that's true. Look back to the cases that were decided at the dawn of the Republic all the way forward. That's the way the country has, that's the United States. Does that mean it's perfect? No, but that's why it's there. And this sort of reached its apex in the 1970s with the Church Committee hearings and all of the domestic surveillance concerns. We put in place a lot of reforms that said, hey, focus overseas. So other countries have different legal frameworks based on their own history, their own priorities, their own series of concerns and scandals. They match up differently to ours. Those services, every legal framework around the world is going to be designed to do two things, or should be designed to do two things. Enable the intelligence agencies to do their mission to protect the nation, while also protecting the civil liberties of that are important to that country, right? And so it's got to do both. It has to both enable and restrict. And each country is going to strike a different balance, but they're all going to be a mix of those. And our argument has always been, Europe has 27 different ways of doing that, all sort of under this rubric of the European Convention of Human Rights. We understand that. They have high-level principles. Let's have that conversation. Let's figure out what are the ways that we think it's okay to do this versus what are the ways that are problematic, taking into account every country is different. So that's been our, sorry, I may not have directly answered the question.
No, that was great. And I just want to, I mean, before we wrap up, we're unfortunately almost out of time. I mean, there is something, I want to ask you if you think that there was something strategic or about why this point received such emphasis in the Schrems II decision, because, you know, stepping back abstractly, you think about data protection law and its purpose. It's about, in large part, making sure that the companies with the data secure it, use it for proper purposes, and don't abuse that privilege. And yet the decision is focused on data protection vis-a-vis surveillance and states. And so I'm wondering, why do you think that the CJEU was trying to do something strategic here? Was it easier to politically to go that route rather than go after industry in effect?
If I can come in here, the reason why this decision is being taken, it's because those were the questions presented to the court. The role of the court is not to assess who has the worst surveillance system, or it could have assessed what Facebook practices, which Facebook was the company as part of the case, but the questions that were sent from the Irish original case were about whether the practices in the US would create an interference with our fundamental rights, both to privacy and to data protection, because those are two separate rights for us. And here, you could argue that, okay, they should have looked at other countries, but the question presented to the court, that the role it has is to answer those questions, is whether the practice of one country, and in this case, the US, are in line with our data protection law. And so you could see here political decision if you want to, but you know, when the same court has to answer a question of whether the data retention practices in Sweden or in the UK or in France are valid, they also do that, and they also invalid like EU legal instruments for saying that they actually infringe EU data protection law. So it's not an anti-US position from the court. It's being asked to check and to oversee our fundamental rights, and it has questions to that. And in that case, those questions included practices in the US, and in some other cases include practices by law enforcement authority in some of our EU countries. And it does that when it's the case, but it's it should be also reminded that who has been found in violation here is the European Commission, as the lead negotiator, has not done its job properly assessing a model. You know, the court has found some issue in the way the data is being used and processed when it's gone to the US, but it's not put into fault the US for that. It's put into fault the EU, the EU body who are in charge of protecting our rights, for not making sure that those violations would not happening. So it's a EU versus EU issue at core, even though it drags other countries into the issue.
Great, thank you so much. Unfortunately, we're over time, but super fascinating discussion, and we really are privileged to have Alex, Estelle, Edith, and Ted with us, who know this inside and out. So thank you to the four of you for joining us. We're going to take a short break and be back at 10:15 with the second panel. And I also want to encourage folks who have questions, of which there are many, to feel free to try to connect during the networking session, which will follow the second panel. So thanks very much, and we'll be back shortly.
Thank you very much.
Thank you.
Good morning, afternoon, early morning, everybody. Thank you so much for joining us. Welcome back to panel 2 of our Privacy Shield event. I'm so happy to see so many familiar names in our participant box, and I hope to be able to connect with you all at our virtual networking reception after the event. Look for that link to be posted in the chat as we wrap up. Also a reminder, you will receive an email tomorrow with a link to your CLE affidavit if you would like one, as well as a survey to rate this event. We really look forward to your feedback. And if you want to attend other Silicon Flatirons events, you can find those listed on our website at siliconflatirons.org. So without further ado, you're not here to listen to me. I will turn it over to the CEO and Executive Director of Bend, Colorado, and our most recent Silicon Flatirons Community Member of the Year, Kay Henze, to lead our second panel.
Great. Thanks so much, Amy. Thanks, everyone, for joining us. Welcome. I anticipate that many of you are continuing from the first panel, which was incredibly interesting. So we're thrilled to have you with us here today. We've got an amazing panel group, which we will go through and do introductions here in just a moment. Just very briefly, as Amy mentioned, I lead the next phase of impact for the Blackstone Entrepreneurs Network, known as Bend, Colorado. We strengthen Colorado's ever-expanding scale-up ecosystem by connecting our high-growth CEOs into other successful entrepreneurs, community, and thought leaders across Colorado to make sure that our robust economy remains very strong. So before I go any further, I do want to also begin by acknowledging that wherever we are meeting on the lands of First Nations people. Here in Boulder, the traditional owners of the land were the Cheyenne, Arapaho, and Ute nations. And I'd like to pay particular respect to the elders past, present, and emerging who lead these communities. So let me go through with introductions with our amazing panel. I'm super excited to speak with everyone this morning. So let's start off with David.
Hello. My name is David Navetta. I am a partner at Cooley and a vice chair of the Cyber Data Privacy Group. My role in this talk is really around helping clients deal with the practical realities of the Schrems II decision and cross-border data transfer. So I look forward to speaking on those issues going forward. Thank you.
Great, thanks, David. Barbara.
Hi, everybody. I'm Barbara Cosgrove. I'm Vice President and Chief Privacy Officer of Workday. Workday is the leading provider of enterprise cloud applications for finance and human resources. I'm here to talk about the perspective of being a cloud provider for B2B, where we're acting as a data processor for our customers' global personal data.
Great, thanks, Barbara. Christina.
Hello, everybody. I'm greetings from Amsterdam. My name is Christina Irion, and I'm an assistant professor at the Institute for Information Law at the University of Amsterdam. And thanks to Amy and the organizers for having me.
Thank you. Lee.
Hi, my name is Lee Tien. I'm the legislative director for the Electronic Frontier Foundation. I specialize in working on legislation in privacy, free speech, and all sorts of other types of EFF issues. And, you know, we've been very active in the policy space that's been opened up by cross-border data flows. And even before that, when the discourse was primarily about the treatment of encryption, which still figures very prominently in all of our discussions today. Thanks.
Great, thanks, Lee. So as all of the panelists have indicated, we're really here to talk about this from a business point of view. What can businesses do now, really in response to kind of this post-privacy shield world? And just to frame it very, very briefly, I mean, when we talk about the digital economy, you know, it's estimated at about $3 trillion, and it's really based on all of the interconnections of people, businesses, and organizations via what is traditionally known as the free and open internet. It's in the, you know, it's in the headlines every day, right? Even this morning, continued scrutiny in regards to our telecommunications network. Also, you know, the thought of Oracle being now a purchaser of TikTok, right? I mean, we see it in different forms in the business community each and every day. So I'm thrilled to have this group of experts here to really kind of help us frame this discussion in regards to, you know, from a business perspective and what businesses can do. So David, let's really start with you. You know, can you just kind of bring us up to speed? There's so much that's changed over the summer. But can you just take us briefly through that, and why? Why should businesses, big, medium, small, emerging, be paying attention to what's going on?
Yeah, so just big picture wise, a lot of organizations, I think up to 6,000 or 7,000 companies in the US had certified to Privacy Shield compliance. From a practical point of view, in negotiating a lot of data transfer agreements between European data controllers or exporters and importers to the US, it was the easiest way to effectuate a data transfer across the Atlantic. So, the big impact, of course, is when that was taken away via Schrems 2. What exactly were companies to do in order to effectuate legal data transfers from Europe to the United States? And so that is the issue that they've been grappling with. And as you saw from the last presentation, a lot of it has to do with interactions between governments and agreements between governments and conflicts of laws, arguably. But when we get down to it, businesses still have to operate, and they still have to figure out a way to adequately transfer data over and across the borders so that they can service their customers, and then we can have a worldwide global economy. That's what we're dealing with now on the big picture. On the smaller level, we're doing the nuts and bolts work and figuring out exactly what they need to do, entering into model clauses, for example, and what the additional safeguards they may have to consider to satisfy some of the requirements or dicta in the Schrems decision. So that's where we currently are.
Thanks, David. Lee, as you mentioned, you have been really leading a lot of the efforts at the Electronic Frontier Foundation in regards to both law and policy. So can you also just kind of add on to David's comments, especially from a policy viewpoint, as we look back, but also look forward?
Well, sure. I mean, I think that, my career in internet law sort of starts in like 1991. And back then, there wasn't that much of the internet, but there was enough that things like encryption and export control and the use of cryptography for privacy were a thing that folks on our side of the world, the advocates, really wanted. And at the same time, businesses were also sort of beset by a great deal of regulation that was making it very hard for them to export high-tech, sophisticated cryptography tools. So in the early period, it was really about, a lot of it was innovation focused, but over time, then the government came in and there was a lot more concern about what law enforcement would do online. That's how EFF got started. Fast forward to a lot of fights over law enforcement and encryption and the development of the online economy. And we realized that you're seeing this big clash between governments as well as major intermediaries, as well as users and everyone who relies on the internet. And that has, exploded into this interesting situation now where all these different national regimes are competing with each other on privacy and on security and on innovation. What we see is that the battles over how to control and regulate the business platforms over which there is so much private data, and so much private data that is both of interest to the commercial entities because of business models that are advertising based or targeting based, as well as interest by national security, law enforcement, and intelligence agencies in this data. And so the problem, a big giant policy problem, is that users are sort of at the mercy of both major commercial entities and of major governmental entities with respect to the privacy and security of their data. And over time, we're seeing that move out of just privacy into larger democracy movements. And we're watching all these concerns about how a great deal of this information, and we saw this especially with Cambridge Analytica, was actually becoming weaponized. So all these issues are swirling around this. And the thing about the Schrems decision is that all of Schrems stuff has really put a lot of focus on how the US national security data collection is itself a threat to privacy. And I'll borrow from the other panel, right? We talked a lot about how there are always clashes about how we're handling national security mission. I would say that this is the big thing, the elephant in the room, really for all of this, is trying to get some sort of a global or more international discussion that is transparent about what the security agencies are doing with respect to national security practices. Because you can't really calibrate the levels between, say, individual EU countries, the EU itself, and the US and the rest of the world if we don't have a more open conversation about what these intelligence agencies are actually doing. Thanks.
Thanks, Lee. So Christina, even last week we saw the EU, some elements of the EU start to take some policy action in regards to Privacy Shield becoming invalid. So being in Amsterdam, can you kind of share with us what you're seeing firsthand?
Okay, so Schrems 2 as a judgment was an earthquake, but otherwise not much has really happened. Internet is still working. I'm here with you on the panel, joining you from Amsterdam. And it seems that, like always with such a judgment, there's a sort of a retracted response, and it will take quite a bit before this really trickles down to companies to feel that. I mean, seriously, Facebook is here in the front line and will face much more stiff wind. But for all other companies, that will still take a while until something will really materialize in terms of enforcement or a clear guidance, which is also a problem because I realize that there is at the moment not yet enough legal predictability and security there for companies to know how now to operate in this environment. In any case, we also have to recognize that Schrems 2 does not affect every company in the same way or every organization in the same way. There are those that are definitely much more exposed to the fallouts from the Schrems 2 decision and the invalidation of the Privacy Shield. And then there are others where, with a bit of care and knowing where your data is and what you are doing, you can respond relatively easy and with modest intervention to this judgment. So it really depends, first of all. What I find fascinating very quickly is that right after the decision was out, we had a statement from Facebook and other large cloud services providers that they won't change a thing. They will continue using standard contractual clauses to transfer data to the US. And that was, let's say a bold statement to start with. And we have seen that this quickly escalated, especially with Facebook now, that the Irish Data Protection Authority, the DPC, has started an ex officio investigation and is preparing an order to actually suspend data transfers based on the standard contractual clauses. This again has been now appealed by Facebook in the Irish court. So it is really a legal drama we are seeing unfolding here in real time. It's fascinating for many of us lawyers. It's also business. I mean, for lawyers, I must say. But it's sometimes hard to explain to normal users and normal citizens what is going on.
Great, thanks, Christina. What a great lead-in, Barbara, for you as as a cloud provider, as a company that's always kind of had a strong position here, even coming out, the day after the decision and everything else. So, love to hear from you in regards to how you're navigating in these turbulent times.
Sure, absolutely. So Workday was certified, or is certified to the Privacy Shield framework. We moved quickly to certify day one. It became available, and to offer that as a data transfer mechanism for customers for their European personal data for us for processing. However, we did not ever just rely on the Privacy Shield. We thought it was incredibly important to have other mechanisms in place and to have flexibility for customers. And so we had already offered standard contractual clauses for processors, and we had also received approval for our binding corporate rules for data processors. Both were additional data transfer mechanisms. So the day this ruling came out, we made sure that we went and reassured our customers that we had those other mechanisms available. We quickly made sure that they understood how to uptake those if they had not, and that they did remain valid data transfer mechanisms as we continue to watch for the additional guidance to come out. In addition, we really focused on the fact that there were references to it being a case-by-case basis, and that companies needed to go and really do their own impact assessment and to review their data transfers. So we internally created a task force and came up with some analysis in terms of information that we thought would help our customers to be able to continue to transfer the data, and provided that for them in the form of an FAQ in terms of the factors they should be looking at. And so, for example, not all data transfers are the same. Looking at, enterprise human resources data versus some other types of data, the likelihood of a government access request, what the company's commitments were in terms of a government response. And we made sure that they had all of that information available so that they could perform their own assessments, and made ourselves available in the event that they needed additional information. And as the guidance has continued to come, as the European Data Protection Board published guidance, we continue to update that with additional information, and are committed to do so in order to make our customers continue to be comfortable that they have the appropriate data transfer mechanisms. We're committed to continue to have a robust privacy program and to be able to support them. But as the other speakers have already said, we're continue to watch, continue to be prepared as additional guidance comes to support our customers.
Great, thank you. So let me just kind of, open it up to everyone here. I mean, the last panel kind of talked a lot about short-term and long-term, and one of the other things that we've seen in the weeks after the decision was really this joint press statement, right, between Secretary Wilbur Ross and then Justice Didier Reyniers. Let me just read a little bit of it. Their comments really said that they are committed to work together, quote, to strengthen the data protection and promote greater prosperity for our nearly 800 million citizens on both sides of the Atlantic. So as you all read that and have looked at the things that have happened kind of, most recently, do you feel that we are kind of embarking on a new approach or a new era of the modern right to privacy? And or do you think that some of this will continue as it has in the past as we move forward? Lee, you want to jump in?
Well, sure. I mean, I'm as a legislative guy, I am reluctant to ever sort of talk about like imminent trends in the law or how things are happening. I tend to see things more like knife fights and want to know who is armed and with how many weapons. So, the thing that is happening right now is a lot of fights all over the place about a lot of different issues. And so I think that the way to understand what's happening is to sort of look beyond the nice words, because people have been saying nice words year after year after year. I mean, we papered over Safe Harbor and Privacy Shield for a long time, knowing that there were gaping holes that the courts have, in the Schrems decisions, have really poked out. One of the things that I think that's really important to remember is that even though this dispute seems like an US dispute, it's got implications for data protection and privacy and security and innovation all over the world, because one of the biggest sort of trends that's always, or solutions to an unclear problem, has always been data localization. And this is something that from an economic perspective, the US businesses have always, that are like heavy in the cloud, are very concerned about data localization, and not necessarily just with respect to the EU, with respect to Brazil, with respect to India, with respect to China. And so these kinds of data localization initiatives are things that go up and down depending on the political winds. And right now, we are seeing a sort of an uptick in the power of data localization. And that's not just about privacy. That there's always, it can be religious protections in a country. It can be concerns for an authoritarian government that simply wants to repress. There are lots of ways in which these will play into a kind of a dialogue about, well, we're going to keep personal data of users in this country, and we want to make it really hard for it to get to others. And so there's a whole lot of play in those joints. Thanks.
David, did you want to add on to that? I wasn't sure if you did.
Sure. During an era where, arguably some of these privacy concerns, the balance is tipped a little bit with Schrems. We want a global economy. We want free flow of data to support global economies. The global economy is crucial for lifting, people out of poverty, for encouraging business across the globe. And so this idea of kind of strict data localization arguably impacts people in a negative way as well, right? So the question is, where does this balance end up, right? And from a business point of view, my concern, and I think we've seen this with almost every major legislation, GDPR, CCPA, is that the big companies, the big players, even though they're the targets, at the end of the day, they're going to be able to afford these and comply with and manage these issues, right? They have the resources, they have the lawyers, frankly, they have everything they need to actually make it work and jump through the hoops, right? I fear that there will be a loss of innovation, smaller companies, smaller businesses. The next big company that helps in the tech space are going to have more difficulty dealing with this. A lot of our clients are smaller emerging market companies, yet they have a global footprint at this point. Even startups right out of the gate are collecting and leveraging data and providing services globally now. So how do those companies react to this, and how do they manage these goalposts that are being erected almost instantaneously? I fear that we're going to lose innovation. I fear that we're going to have some of the benefits, and there are a lot of the internet economy could be lost by some of these, frankly, walls that are being put up around countries and the data that's being processed. So that's, again, from my perspective, the counter to, yes, the privacy concerns are real, but what's the other end of that look like if we do have these walls erected?
Yeah. I think it brings up the point, right? I'm sorry, Christina. Did you want to jump in?
Yeah, I'd just like to say it makes sense also to look from here, but Schrems 2 decision is really, or the court did something unprecedented. We have a court decision on almost an identical problem, first in 2015 and now again. This is something that doesn't happen all the time in Europe. There is really quite some emphasis and attention to this fact that we have crafted the GDPR, the General Data Protection Regulation, which is a massive piece of legislation, but it was supposed to actually bring us privacy inside the digital ecosystem in a digital environment. And the Schrems 2 judgment is defending the GDPR in a way, and the existence of it. What I want to mention is that I'm actually really against pitching data flows and trade, digital trade, with privacy and data protection against each other. I really think that the success formula in the long run will be to find something that can flow but integrates the privacy with it. That is at the moment not the case. Yeah, everything that flows is in one way or the other really exposed to commercial but also state surveillance. And we have not yet really managed to hammer out a solution that would reconcile, as already Lee said earlier, both in a sensible way. Yes, borders are sometimes not nice. I also enjoy living in Europe, where we are in the Union, traveling between the countries without borders. But at the same time, we have at the moment for protecting the fundamental rights of users, only the nation states and the European Union that are upholding and effectively enforcement human rights standards. Unless we get to a point where we have something that, the global international community, or at least a region, is carrying together, we cannot forego national protections of personal data. They are really, really crucial. So in the midterm, I don't think there will be a new whatever shield or safe harbor. I don't know how they want to name it. I even think it will be hard for the UK to get a privacy channel, to be very honest, because they have similar problems that the court contested with the US at the moment. So we have to see how that can work. At the same time, the internet is not breaking into pieces. It is not happening that every service needs to be fully integrated, and many businesses, we should not forget that, that's also a question to my colleagues here, the businesses themselves are choosing data residency when they are actually moving their data into the cloud. And already after Schrems 1 decision, we realized a huge uptake in residency in Europe by private businesses that require that their data is stored in data centers and mirrored in data centers in Europe. And I should also mention that in 2015, Dropbox and also Twitter have moved all their non-US accounts to Ireland. So it is possible to react to these decisions. It will be a strategic decision, but again, there are ways to do and handle that and keep on supplying these services.
Yeah. So, it puts the businesses in a tough position in a whole host of different ways, right? But one of them is that, I'm sure Barbara, and I certainly remember it well, you get thousands of requests for data almost every day in a large corporation, right? From governments, from private entities, from all kinds of different places. So, how should businesses be dealing with that increased request, quite frankly, in regards to data? Barbara, you want to start that?
Sure, I can start there. I think, again, it's really important to go back to not all businesses end up getting those surveillance requests, and not all businesses have the same privacy processes. Even going back to the previous comment about commercial surveillance and use of data, my concern is that there's a handful of companies that have made headlines over potential misuse of data, and that causes question about all companies, where there's a lot of companies that have very strong privacy commitments, strong protections, and especially in an enterprise B2B, you're making commitments to a customer, you're demonstrating it. And so I worry that some of those headlines can create a perception that all companies are doing that, and I really don't believe that's true. I think there's a lot of companies that really respect their privacy protections to their customers. We're one of those that use data in the way that we're authorized to by customers to deliver the service. And similarly, as we go into the access requests, many companies have never received one of these data requests and are unlikely to in the future based on the type of data that they have. In terms of the surveillance, the US government's really focused on particular types of data, mainly communications, that's useful for national security purposes. So if you get into a company's global human resources data, financial data, various business data, it's incredibly unlikely that they're going to go to the cloud provider to get that type of data. But in the event that a data request were to be made, I think enterprise companies have to be prepared to commit to redirecting those requests to the customers, in line with following the Department of Justice's guidance, of course. But they should be prepared to commit to challenging any gag orders. They should be willing to litigate any objections, and to really stand over the fact that it's their customers' data, and be prepared to commit to their customers that they'll do so.
Yeah, could I jump in here for a second, Kate?
Yeah, please, Lee.
Yeah, I wanted to just sort of amplify what Barbara is saying, because one of, as everyone recognizes, one of the sort of weird asymmetries in the whole problem is that the companies are the whipping boy for the U.S. for many of the issues that the U.S. government is creating with its national security apparatus. And even without the international frame, there are a lot of pushes within the domestic U.S. law just on basic due process and civil liberties with respect to the question of how long can a gag order really last? What are the responses? What can a company do when it wants to tell somebody, but it can't? Or notice more broadly under the shift of regimes from MLAT to Cloud Act. And there are all sorts of really, really interesting, difficult issues being negotiated right now around the world on how law enforcement's access to data being held by these private companies all over the world is going to be handled. And that's what I was trying to point out at the beginning, was that, there is a real question of the role of the intermediaries, the companies, the platforms, service providers with respect to government, whether it's law enforcement or intelligence, and the consumer, because they're sort of caught between these two places. And we haven't had a full participation from the government side on intelligence and national security. And that's either in the United States or, as many people have written, on the EU side, right? I mean, because many times the way these cases have come up through court, they come up and then the way it's presented, they have to say something about the other third-party countries' national security setup, but they don't have to talk about the ones within the EU. And so when, Alex Joel is worried about how this isn't fair to the United States, it's half true, but the answer is that we need to have a broader, more transparent dialogue internationally and globally that includes ordinary people and not just the bureaucrats and the folks with security clearances, because otherwise you're never going to be able to get anything like a process that works towards harmonizing folks' expectations. Thanks.
If I might, Lee, I love your optimism on this in terms of we're going to somehow get...
I don't know it's going to happen, David. I think it's what it has to happen.
The intelligence apparatus of all the countries of the world to sort of agree on some sort of uniform privacy protection. But I do think, to truly solve this problem, that is actually, if you're looking just on the surface of Schrems and what the decision said, that is the solution. But I don't know if it is actually a solution. How do you actually get there, right? We can talk about collaboration. We can talk about companies and being put in a hard spot. And the countries, and including European countries that all have their own intelligence apparatus that, probably do something very similar to what the U.S. does, and we may not even know about it, and et cetera, et cetera. But again, getting back to the practical reality, and maybe Barbara can weigh in on this too. I don't think businesses can wait for that to happen because, frankly, I don't think it will ever happen, to be honest. But so where does that leave us? I mean, and Christina talked about respecting, countries having to impose their privacy and data protection standards across the board and having integrity there. But I don't see where it goes except to walled off and very segregated and siloed data processing activities. So Lee, I would love to get to where you want to be, but is that going to happen on a practical level? And what do we do in the meantime? I mean, Christina, you're saying the internet's not failing, but arguably, the entire world is transferring data illegally from Europe to their various countries that don't have adequacy decisions. That's not a good state to be in, even though the internet hasn't stopped. So where do we go with this on a practical level, and how do we actually solve the problem? That's really what I'm interested in. And I don't have the answers right here today, but that's where we need to go.
And my worry is, Dave, I don't believe companies would stop transferring data either. I think, in order for a global company to function, they may end up emailing data instead and believing that's not a data transfer. You know, instead of putting it in that centralized place, it's going to end up getting sent possibly through less secure means in order for them to operate. So I think it's critical to find a way for these transfers to continue in a way where they can also make sure that the data is being protected appropriately and not ending up having data just all over the place in order for the business to function. But I do think it's important for us as a step forward. I don't believe it solves the whole thing, but to continue to look at passing a federal privacy law in the United States. I think that would do wonders in terms of showing a commitment to data privacy. I understand it doesn't address all of the underlying questions around surveillance practices, but I do think it would help show the US's commitment in order to data privacy and to protecting data. And, you know, we're very supportive of that in terms of getting that moving forward.
I'd like to come in because earlier this year, what made really headlines in Europe was the Cloud Act. You know, a lot of discussion. What does that mean for cloud providers here in Europe when they are part of Microsoft Azure, of another large global cloud provider? Are they still under any obligation towards the US government, even though the data is stored here not so far in a cloud center in the Amsterdam region? And, you know, it's very hard not only to explain to journalists and people, normal audiences, why is it possible that a government that sits, you know, overseas in the US can order a cloud provider to turn over a file that is stored here next in Amsterdam? And why are there not other procedures like the mutual legal assistance treaties then used that are actually creating some sort of due process for this type of data exchanges? Yes, they are slow. Yes, they are cumbersome. Yes, they need to be improved and also get to the digital age. But all in all, a part of the problem and of the squeeze many cloud providers and many companies find themselves in is also exactly this type of trying to have a long arm reach from one government to the other countries, but then in the end also requiring that everything has to flow freely through the world. Part of my work is also that I'm looking a lot at emerging digital trade agreements and negotiations in this field. And already we see that this whole data flow debate has shifted towards trade law fora. And that, for example, at the moment at the level of the WTO, there are negotiations to ensure new commitments on free data flows. But this will not solve the problem. What I'm saying is that this is just a continuously moving target, but as long as we don't get the data, the protection, the privacy inside the data flows, we will see always these cracks opening up again and again. And that's why I'm happy to hear that there's now much more support also for a federal data privacy act. And I still hope that we need to find a solution for the non-US persons such as me here, because as a non-USPA, I have no protection, and that is not working in a global, planetary scale connected digital environment. Yeah.
Great, thanks, Christina. So let's kind of shift a little bit to just the market, right? Just the market forces, right? So it was interesting. You know, Cisco does a lot of research. Earlier this year, they published their data privacy benchmark study of 2020, which was really fascinating. Just a couple of points in it. The companies that they surveyed, which was over 2,800 security professionals across kind of a wide range of industries, they said that in their companies, on average, for every dollar that they invest in regards to privacy, they see a 2.7 rate of return on that $1. The other fact that I thought was really interesting in the survey results was that 82% of the companies stated that when they were negotiating or working with a third party, that their access and their passage and holding basically of privacy certificates was part of the purchase decision for these individuals. So can the market, can these companies that are investing and are putting a stake in the ground and are using privacy as a competitive advantage, is that enough? Can the market forces be enough to ensure a right to privacy in this digital economy?
I'll start out with that. I mean, we see privacy now being taken into account much earlier in the development of organizations, especially those that are data centric. So, the CCPA, GDPR, the new laws, the various stories that have come out, Schrems 2 itself have created much more visibility of the issue. And people do see it now as if you are building a product or a service and designing privacy into it, that's viewed as an enabler. It's helping you get to the market, right? That has been a shift over the last, I'd say, 2 years, where a lot of, especially our emerging growth companies, their engineering was only focused on product and service, right? Now it's product, service, and privacy and security, because they know at a certain point, if they're going to make it, especially, they're going to be questioned on those points, right? And if they're B2B, especially, their customers are going to demand it ultimately. So I think this is good news. Again, it's on a micro level, it's not on this global level, but we're seeing these issues being taken into account much more seriously, and being asked questions about GDPR from even small companies, now Asia, now Brazil. How do we actually manage all this? Now, it's not easy, of course, but at least the question, even in the startup and emerging growth space, is being asked earlier. That's great news, in my opinion.
Yeah, I can jump in on that one as well. I mean, I've been with Workday for 13 and a half years. So I'll say from the very start, it was critical for us to build privacy into our program. But I do think there needs to be a not just trust, but a verify approach, especially depending on the type of data that you have. So having those third-party certifications where you can demonstrate that you're doing what you say you do is critical, and I think should be helpful going forward. It's one of the reasons why when we went through our Privacy Shield certification, we also had the TrustArc review of it, so that in addition to the self-certification, we have a review from an independent third party. It was why we did the binding corporate rules with Ireland being our lead data protection commissioner for it, the supervisory authority, so that we could show that we put the program in front of the data protection authorities and we're willing to go through that review and audit. And again, I think that shows your customers, their users, that you're willing to stand behind the program, that you're doing the right things. One thing that I think we should continue to work towards going forward in this is looking at other mechanisms, other certification mechanisms that GDPR had envisioned. So codes of conduct, for example, and we've been actively involved in a European cloud code of conduct that aligns to GDPR compliance that we're hopeful the data protection authorities will approve. And having those programs, especially where there is a monitoring body in Europe that oversees it, I think can be helpful. One of the projects they're actively working on, they announced recently, is adding a data transfer module to that cloud code of conduct. And again, it would be overseen by a monitoring body in Europe. It would have been approved by the European data protection authorities. And all of those, I think, continue to show that companies are trying to do the right thing, that they're having third parties do independent monitoring, and they can stand behind their program and help build this trust and hopefully help demonstrate that they're doing the right thing going forward.
Great, thanks. So just one more question, and then I'm going to kind of open it up. We've got a lot of questions kind of coming in the Q&A. So, as I've been kind of doing some research and reading, I mean, and I think it's been a consistent theme in the other panel as well as this one, is there any, and to use Christina's commentary, right, the internet is still flowing, it hasn't broken, but we seem to be having a similar conversation, right, over a long period of years. So, is there anything that we should have been doing or perhaps can do now, since, Privacy Shield was enacted 4 years ago, right, before it became invalidated, to ensure that the internet doesn't break, right, to ensure that the cross-border data transfers continue without interruption for both the companies as well as for all of the businesses and consumers that want to receive services, right, at an exponential rate in a digital format?
I can quickly, again, to me, continuing to work towards passing federal privacy law is key. And, we've been supportive of that, but continuing to go forward to show commitment to protecting privacy. But also, I think we really need US and Europe to reach a common understanding of what's appropriate in the surveillance context, which others have already touched on. I think both of those are key factors to getting this, not having it happen a third time.
I'm going to agree with Barbara, but amplify those 2 points. First of all, I think in terms of a federal privacy law, I'm not wedded to the idea of it necessarily being federal, but what is important is that it is effective, that it is enforceable. One of the things that we see in the legislative battles over privacy is often a strong emphasis and obsession almost with what the details of the actual conduct rules are, with virtually no consideration given to an optimal or adequate level of enforcement. So we under-resource the agencies that have, or the state attorney general, or we don't allow private rights of action, or with respect to, and this is the slide over to Schrems, you can't even bring a lawsuit because you can't demonstrate that you had an injury under US law for Article 3 purposes. And why couldn't you demonstrate you had an injury? Oh, because the government classified everything about the program. And so I know that our panel is more of a business-oriented panel, but I feel compelled to say that all of the many of the problems that are difficult for business are because we have not had an open, honest, and candid conversation about how much data gathering the intelligence agencies are able to do, the law enforcement agencies are able to do, and with respect to the internal processes of the companies. And so I feel like that is a giant elephant in the, well, everyone acknowledges it, but nobody knows how to deal with it. And so I don't have an answer, but I do not think we can get to anything that is like a long-term stable answer without recognizing the importance of enforcement, the difficulty of handling national security and law enforcement access to data when ordinary users have due process and civil liberties concerns about it. So, thanks.
Yeah. If I can comment, I also think it's a watershed moment for, let's say, Western democracies to hammer out something jointly, because also in the US, you have now experience with worrying more about what happens with private data when it is transferred to a country which has very liberal thinking about surveillance, for example. We have a number of revelations recently and suspicion, and in general we are seeing that there's less and less trust, but also that inside the US there is a new sensitivity, let's put it, especially vis-a-vis China, but also Russian services that are becoming increasingly popular with US citizens that are maybe potentially government officials or in the army. This is stuff that 6 years ago wasn't really happening, but now these sensitivities are also there. I think if we would recognize mutually that what we feel in Europe sometimes vis-a-vis what happens to our data in the US is now similar to what the US now feels sometimes about China, and like trying to make the best out of it would be actually to come up with a democratic solution that joins the interests of Europe and China, instead of like floating apart in now 3 large data realms that are emerging in the world, which is on the one hand the more authoritarian model, and then the free flow libertarian US model, and what we are in Europe with this, what they sometimes call the bourgeois model, that we are protecting. We want to protect everything, but actually we are not a big player in any of these digital services.
Thanks, Christina. Oh, go ahead, David, sorry.
I'm just gonna finish off. I mean, from a pure business perspective right now, we're trying to understand what, where the herd is, and advising clients to stay within that herd. Don't, I think Facebook was starting to talk about Article 49 derogations as a basis. And so, at the end of the day, from a liability perspective and a risk perspective, if you understand what others in your industry are doing and emulating that and working, frankly, and Barbara made this point, together to come up with solutions, you're going to be in a much better space. And these data flows will continue until a lot of this gets worked out in other venues. So that's from a business perspective, trying to understand where the herd is, achieving full herd mentality, to borrow a word in the news recently, may be a good thing in this context for businesses.
Great, thanks, David. Okay, so in keeping with the Silicon Flatirons' long tradition of our first question for this amazing panel coming from a current student, I'm thrilled to welcome Stacy Weber into the conversation with our first question. Hi, Stacy.
Hi, thank you so much for an incredible discussion. As a gift to get to listen to all of you. I'm curious, as you were talking more and more about a federal law and the extent to which that can institute practices and generate some goodwill between the US and European countries. How do you think about the upcoming election affecting that, whether it's from the presidential side of international dialogue or the legislative side of the feasibility of passing a federal law? Do you have any particular thoughts on how the outcome could impact that?
I'll jump in. It's really hard to tell. I think that in the current situation, I mean, you've seen what the Congress has been like. They don't get a lot done right now. So the odds, so I would be concerned that unless both houses of Congress actually shift, that there's a lot of possibility for gridlock among the privacy advocacy community. We sort of, even without looking at who's in the White House, we just sort of said, yeah, it's going to be, we can't imagine that it would happen in less than 3 years for something to actually come out. I mean, it's very encouraging, right? This last year and a half, there have been a lot more privacy bills, and on some of the important aspects, both non-preemption of state privacy law, as well as enforcement with privacy rights of action. Private rights of action, there is a little bit of movement of sort of the Overton window, right? I mean, it used to be that the moment you went into Congress, you gave up preemption, you gave up a private right of action. You just assumed that the best you were going to do was get a starved FTC. Now there are bills with more, but we still don't know really where the political weight is going to be. So the actual fight, even though the fight is going on both at the state level and at the federal level, and it's really almost a sort of a back and forth game, because we assume that what gets passed in the states will be seen by DC as, oh, somebody actually passed something that had these in it. But then when you start seeing multiple models, like maybe a different law in California from a law in Washington or a law in North Dakota, then things get confused again. And so one of the problems in this area, and this sort of also relates to Kay's question about markets for privacy, is that privacy is so hard to have metrics for, and so much of it depends on what is happening behind the scenes. I mean, part of the problem is that people continue to learn things about how their privacy is affected because they have a mental model or a folk model that is not accurate with respect to the market for personal information. And so we're very much still, I think, in a process of educating consumers about what has been happening to them and understanding the details of, an advertising model. But that makes it really, really hard to judge what's going to happen on a privacy law, because all the action against the big companies is in a context where it's about their are they censoring people? Are they contributing to unfair discrimination in housing or in employment? And so even though the companies will be embroiled in a privacy, all of these other battles are happening as well. And that's all going to sort of affect who or which committee or which particular officers are actually going to be pushing this sort of bill. I'll stop there.
Great. Thank you, Stacey. So we've got time, I think, for probably one more. I'm going to take two questions and kind of combine them into one from Kathy as well as from Darcy. Both of them are kind of saying, what can companies do now, right? What's kind of some practical next steps for companies that are transferring data today, beyond kind of the standard contractual clauses. So let me just, if we can maybe just do a round robin of, what's your best advice for companies today in this environment? Barbara, you want to start us off?
Sure. I think first and most importantly, it's to make sure that you have a data transfer mechanism that's still in place. If you were a company that was relying on the privacy shield, that you have moved on to standard contractual clauses, or that you have binding corporate rules, and really to go through and review all of your data transfers. Secondly, I think it's really important to do a transfer impact assessment and to go through, evaluate what type of data is being transferred. What is the risk of government access? Do you have appropriate technical measures in place? And to document all of that so that you have documentation that shows that you understood this came out, that you have data transfer mechanisms, that you understand what's going on, and that you've evaluated your risk and made a decision based on that, the type of data, the likelihood of the access, the contractual provisions you may have in place, and the technical measures, and then just continue to evaluate. And as Dave said earlier, I think connecting with peers in your industry is critical right now, to be doing benchmarking with them, to be talking to them and making sure that you're aligning with them.
Great, thanks. Lee, you want to add on?
Well, it's hard for anyone who's not big to do anything other than just sort of like try to keep their head down and do as much as possible to remain privacy safe. But, it's really true what we've been saying about how it is different for the very large companies and for the small enterprises. I mean, EFF is a nonprofit, but we are still subject to subject access requests, for instance, from folks in the EU. So we understand what it's like to, if you're small like us, and suddenly a lot of people start asking you, we know what it's like to have to deal with that. The problem, but when we talk to the companies, and we have been talking to companies over the last couple of weeks about what is going on, there isn't much new to say. I mean, I think I agree with everything that Barbara and Dave have said, but I would also say that it's important to think more politically now about what kind of a privacy framework or system we're actually building for this country and globally. I mean, it's sort of not enough to just sort of hope that others are going to do that. If you've got interest in your business and you want to shape this dialogue, you should engage, because now this actually probably is as good a time as any over the last several years to actually try to improve the state of our privacy laws.
Use your voice is part of what I heard in Lee. Christina?
Yeah. I also think what everybody before me said has a lot of value. I think the most exposed are those companies that really fall under the ambit of FISA 702 and also the Cloud Act. These companies, they have to really watch out, because they are beyond fixing at the moment in a way. Yeah? But other companies are not that much exposed from the privacy shield invalidation. They can still move, for example, to another safeguard measure under the GDPR, and they just have to be careful that they they are having everything in place, just as Barbara said earlier, and document well their decisions. Also, data protection authorities, the enforcing bodies here in Europe, they will enforce by priority. Yeah, they always have this slogan that you have to be selective to be effective, and they cannot go like in a sweep. And they also don't want to be just, having a hammer and everything is a nail. They are going to be sensible. They have shown that already in the past, that they are not going after small fish. They go after big fish. They are going after big fish that is showing not enough compliance effort. That is like the combination that is dangerous. And the only joker that will remain here in this game is that the GDPR can not only be enforced by data protection authorities, but there's also still the way to seek remedies at a civil law court. And that is something that is hard to control. The docket is not anymore under control of authorities, but actually almost everybody who can have some sort of a legitimate interest can go after every data exporter. But that is also quite unlikely to hit smaller companies. It's really big and exposed are, also the names that we know from the case. It's Facebook, it's Google, and GAFAM family, at large.
Great. David, you want to close us out?
Sure. I agree with everything that's been said in terms of practical steps. I mean, one thing that companies are starting to do, it was mentioned in Schrems, additional safeguards that may be necessary in conjunction with use of model clauses. So we're working with clients and seeing clients trying to determine what that means. And for instance, end-to-end encryption, Lee mentioned encryption being tied into all this. That's actually a pretty good way to stop surveillance if you have true end-to-end encryption, right? So, that's something that could be considered down the line is additional protections that might get you into a better state as a processor of information in terms of what, is currently required under Schrems.
Great, thank you. Well, just a huge thank you to all of our panelists, an amazing conversation, covered a lot of topics. And then also just a thank you to the team at Silicon Flatirons for thinking about this topic. Obviously very timely from the day that I first talked to Amy to today. There's been so many changes that have already happened. So certainly a very thought-provoking and timely discussion to bring into our community. So a huge thank you to the team at Silicon Flatirons. And then also just to our audience, thank you for joining us today. Obviously, we weren't able to get to all of the questions, but I encourage you to please stay tuned. They're going to put up the information in regards to how we'll move into the reception, which is an opportunity for everybody to continue this dialogue and certainly to bring forward any questions that we haven't had the chance to answer. So thank you all very much. Have a great rest of your week.